So, in this video, we'll discuss part 9 that we have framed in regards to Article 21, which provides protection of life and personal liberty. So, the first heading that we have framed under this part is ecology, and relation to ecology we will discuss two important leading cases, MC Mehta versus Kamal Nath, and it was a case of 1999 decided by the Supreme Court, and the second one that is regarding animal and environment legal defenses Fund versus Union of India in 1997. So, in regards to that, we would like to discuss the first one, where in the first leading case, that is MC Mehta versus Kamal Nath, it was pronounced by the Supreme Court. It has enunciated the very doctrine of public trust based on the legal theory of the ancient Roman Empire. The idea of this theory was that certain common properties such as rivers, seashores, forests, and the air were held by the government in trusteeship for the free and unimpeded use of the general public. The resources like air, sea, waters, and the forest have such a great importance to the people as a whole that it would be totally unjustified to make them a subject of private ownership. The concept environment bears a very close relationship to this doctrine. The doctrine enjoins upon the resources for the enjoyment of the general public rather to permit their use for private ownership or commercial purposes. It was thus held that the state government committed breach of public trust by leasing the ecologically fragile land to the motel management, as it was declared by the Supreme Court in this very important leading case, NC Mehta versus Kamal Nath in 1997. And now we'll go to the second important leading case relating to ecology, that is animal and environment legal defense fund versus Union of India, and it was also decided in the same year 1997 by the Supreme Court, where it was pronounced that every attempt should be made to preserve the fragile ecology of the forest area and to protect the tiger reserve and the right of tribals in the state of Madhya Pradesh, as it was decided in this important leading case, Animal and Environment Legal Defense Fund versus Union of India in 1997. And now we'll go to the second heading, that is relating to environment, and also in that connection we'll discuss another important leading case, that is MC Mehta versus Kamal Nath. It was decided in 2000 by the Supreme Court. So also another important case, MC Mehta versus Union of India in 1997 by the Supreme Court. So, in the first important leading case that we have selected, which is falling under environment and relating to Article 21 of the Constitution, and that is the very disturbance of the basic environment elements, namely air, water, and soil, which are necessary for life, would be hazardous to life within the meaning of Article 21 of the Constitution, as it was held by our apex court in this important leading case, MC Mehta versus Kamal Nath in 2000 by the Supreme Court. And in regards to the second important leading case in relation to environment is MC Mehta versus Union of India, and it was a case of 1997 where it was pronounced by the Supreme Court that the precautionary principle requires the state to anticipate, prevent, and attack the causes of environmental degradation. And now we'll go to another facet that we have selected under part 9, that is relating to those industries and how they pollute. So, in regarding that, we'll discuss one important leading case, and that is relating to Indian Council for Enviro Legal Action versus Union of India in 1996, where it was held that if an industry is established without requisite permission and in blatant disregard of law, in the detriment of citizens' right to life, the Supreme Court can interfere to project right to life. The rule of absolute liability applies in such cases, as it was held in this very important leading case, Indian Council for Legal Action versus Union of India, and a case of 1996, and it was decided by the Supreme Court. And now we'll go to another facet that we have selected under this is pollution free water. So, regarding pollution free water, also we have selected that important leading case which already we have discussed. Dr. B.L. Vadera versus Union of India in 1996, where it was pronounced that right to life under Article 21 includes the right to enjoyment of pollution free water, as it was decided in this very important leading case, Dr. B.L. Vadera versus Union of India in 1996 by our Supreme Court. And the next one is regarding smoking, and that smoking in public places And in relation to that, we would like to discuss another important leading case, and that is Murali S. Dura versus Union of India in 2002. Supreme Court expressed that in any case there is no reason to compel non-smokers to be helpless victims of air pollution, as it was pronounced in this important leading case, that is Murali S. Deora versus Union of India in 2002, and it is relating to smoking in public places. So, under Part 9 that we have framed in regards to the very provisions relating to protection of life and personal liberty as envisaged under Article 21 of the Fundamental Rights, and its very scope, jurisdiction, and ambit, how it was expanded and how it is being widened day by day by our apex court or Supreme Court, that we have analyzed critically. So, in our upcoming video, we will discuss the last part that we have framed in regards to Article 21, that is Part 10. And under Part 10, we will discuss all other facets which are falling under Article 21 in relation to protection of life and personal liberty, that we will discuss in our upcoming video.